is now completely contradicting everything he told police when these individuals were not in the interview room. Again, that is snitching. And here is a reason he is explaining in 2015 why snitching is a problem. So when you look at it for both the specific impeachment of my line of questioning about this interview, but then the larger conspiracy, in this case, people do not want to come in here and testify. Mr. Copeland is not the first witness. We've had Ms. Archillian Bennett, who testified that what she never talked to the police, or what she told the police was a lie. But then when you come into court and have to face the individuals that you were accusing, have a different story. Same thing with Adrian Bean. Adrian Bean had a whole interview with Detective Quinn, identified Mr. Williams, identified other individuals who participated in a crime with him. But when he came into court, did not testify. So therefore, snitching is an issue in this trial. Mr. Copeland is talking about his reasons for not wanting to snitch, which is very relevant in the totality of this case. So for multiple reasons, we believe that this portion should be allowed to be played.
All right. Any other counsels wish to be heard on this particular issue from 4:11:30 to 4:12:35? Mr. Weinstein?
No.
Mr. Matthews?
No.
Ms. D. Williams? Mr. Harvey?
Made it at a time when the witness had a motivation to lie. Even after this particular event occurred, but can't be admitted to that purpose.
All right, okay. All right, sir. Mr. Steele?
Just as the court goes through your ruling, the state's information, what they just said about people come in and then face Mr. Williams et al. And then are reluctant, it's not what I understand. I understand Ms. Bennett was upset because the district attorney's co-worker was inappropriately communicating with her. I understand that Mr. Bean told another detective at the hospital when he was first arrested that he did not have information. He was told if you include Mr. Williams, then you can get out. It'll be better for you. With Mr. Copeland, who's testifying, he has stated that he's been pressured by the prosecution. So this whole creation of pressure is a theory of the district attorney without zero proof. So I don't believe that should weigh into your analysis at all. I also agree with Mr. Harvey that once the reason for the fabrication or the improper influence is birth, then under Tome, which is T-O-M-E, United States Supreme Court case, and in Georgia, Adams, A-D-A-M-S. It's also in the statute, which is OCGA section 24-6-613, because the motivation of Mr. Copeland is clear. He's in custody, he wants to get out of custody, and he's making statements. These are not prior consistent statements at all. The state is saying it's prior inconsistent statements. Sometimes they are, but sometimes they're really prior consistent statements that they wish to get in. Because Mr. Copeland really is not inconsistent. He said, yes, I probably said these things, but I said them because I was motivated to get out of jail. So the state is relying on inconsistency. I believe that they're really relying on consistency, and I join Mr. Harvey about it's not proper for a prior consistent statement.
All right, sir. Okay. In considering 4:11:30 or thereabouts to 4:12:35, the court is in agreement. At least it's a impeachment by contradiction for the reasons that the state's proffered. Whether or not the issue of snitching is relevant before the jury, and whether or not that is an issue that several witnesses have testified to would be relevant. So, but the court's primary ruling is based upon impeachment by contradiction. So that will be authorized to be inquired into. All right. Let's turn now to 425 to 425:33. Casey talking about Shannon beefing with IG people. Yeah, you can flesh it out, sir.
So just a little context, John. This is after. Obviously, you know, this is after the episode of Mr. Copeland being shot at outside his house. It's also after a January 28th episode where we've heard testimony. Mr. Copeland, Demekion Garlington, and Mr. Stillwell were all in a car together, and that car was shot at, and the car stopped working, if you recall that testimony, Your Honor. So there's two different shooting situations involving Mr. Copeland, one where Mr. Stillwell was also apparently or allegedly in the car. And Mr. Copeland is, I believe, making reference to Mr. Stillwell having issues with some of Mr. Copeland's enemies on Instagram. My objection to this is that this is based, Mr. Copeland's in jail, and it's unclear how he's aware of this, but apparently he's been told about Mr. Stillwell having back and forth with these individuals. From my recollection, you know, I've been through all the discovery numerous times. I don't recall in discovery seeing any of this alleged back and forth during this time frame involving my client on Instagram. So I haven't seen any documentary proof of any of this, but so I don't know exactly what Mr. Copeland is referring to, but from my understanding of the context of the statement, Mr. Copeland is merely passing on hearsay information about what Shannon is doing on Instagram. Okay. Mr. Copeland does not have access to Instagram, obviously, as he's making these statements.
Can I hear it, and what transcript page is this from?
It's going to be page 47, but page 47, line 9 through page 48, line 15. I do think for context, you need to start at 424, which is going to be page 45, line 25. Page 45, line 25.
Page 45, line 25?
Yes.
Okay. All right, go ahead and play it, please.
I didn't see no face. It did. When I see him jump out of the car, kind of face so much. Who? The boy that was showing at my house. Who? Who? Who you know to be driving that silver Bonneville? I could never picture that. That's something I could never get. So who do you favor? Say. Your friend Tay? Which Tay? Well, Lord, my partner at the moment. Where you from? Simpson. You from Simpson? How can I find Tay? his Twitter arguing with Shannon. He did what? He's on Twitter arguing with Shannon. He on Twitter arguing with Shannon. This recent? Yeah. When? Right before y'all came and got me, I was just trying to call my baby mom. She just told her. So him and Shannon on Twitter arguing. They been about what? Me. Saying it. You still alive because we miss you. You still alive because we miss you? Like they miss, like shooting at you? When did you see this person? Like before the incident the other day with your baby? Before the incident with you and your baby, you said the dude was shooting at my house. Which incident are you talking about? Huh? You said the same boy that was shooting at my house. Okay, which?
I think you're right within that 425.
Okay. Yes.
So it's I heard it, and I'm assuming Your Honor heard it. He says Tay, and they're trying to figure out who Tay is.
Which Tay?
The Tay, I don't know which Tay at this point.
Okay.
There's a Tay that allegedly shot at Mr. Copeland, or that's the state's theory, and Mr. Copeland is saying Tay, but he's not identifying Tay. And he says something about that Tay is having an argument with Shannon on Instagram, and then he was like, when is this happening, is what Investigator Gaither asked. And Mr. Copeland says, essentially now, or when I got locked up. And he said, that's what my baby mama told me. So it's clear his source of information is someone else who's telling him about this alleged internet argument, and he doesn't have any personal knowledge of it.
All right, sir.
It adds absolutely nothing to the context of this statement, other than it brings in hearsay evidence about my client, which I object to.
All right.
You're right, the section about Twitter, we won't play, we'll just pick that up when Detective Gator trying to clarify, like the issue, when was he shooting at you? Just try to clarify that question, but we will take out, I think it's probably about 425.
425.31 to what?
No, 425 to 425.
Okay, 420. 425.20.
No, 425.00
Yes, ma'am.
to 425. It's about 31 or 30.
31, 32. That's what you said you're going to take out? Because that talks about the Twitter conversation. All right. Mr. Sharp, anything else from that particular time block that you wish to be omitted?
No.
All right. Any other counsel wish to be heard about anything from 425.00 to 425.33? Mr. Weinstein.
No, Your Honor.
All right, Mr. Matthews.
No, Your Honor.
Ms. T. Williams. Mr. Harvey. All right, Mr. Steele.
I think first.
Okay, all right. So the state will be directed to omit that particular portion. The rest of it can be played. All right, let's move on to 6, and that would be.
This next is
Hold on, let me just frame it right quick. So, 438.35 to 438.40, and you've indicated that. Casey saying that he has not hung out with Shannon Lodi since they shot the car. Confusing under 403 is a pronoun they is meant to refer to people shooting at Casey, Shannon Lodi, but could be misconstrued.
right.
Okay.
So
Right.
essentially, they are asking about when's the last time he hung out with Shannon and Lil D, who's Demekion Garlington, and he says not since they shot at the car. I think any reasonable interpretation of that, based on someone who's spent hundreds probably thousands of hours reviewing the discovery in this case, which I have and the defense counsel has, any reasonable interpretation would mean they he's referring to is the people that shot at him, Shannon, and Lil D in the car on January 27th, I believe it was, the day before the statement on the 28th. However, the jurors have not gone through all the discovery 10 times over as the defense has. So they have limited knowledge of everything. And when you listen to the statement in a vacuum, the reasonable interpretation is he hasn't hung out with Shannon and Lil D since they shot at the car, which makes it seem like Shannon and Lil D were shooting at a car. It's confusion of the issues. It's likely to mislead the jury. And again, Your Honor, this is another one of those things I said earlier, this is not a normal trial. Yes, theoretically, first of all, there's no need to bring this confusion into this trial. So there's no prosecutorial need for this little excerpt to be played. But sure, theoretically, we could clear this up during cross-examination under normal trial circumstances. But when this is played, there's going to be several days in between that time where the jurors are likely to have in their head, if they're scrutinizing every line, oh wait, Shannon and Lil D were shooting at a car, and that's going to affect the way they look at my client. And when in fact, we can just clear that up at the time of him saying it by deleting it, as opposed to me having to come back days later and try to clarify and draw everyone's attention back to this incident and this statement. So I just think under 403, to avoid confusion of the issues, we could easily just redact this little segment and clear up any potential confusion.
And Your Honor, before I even play it, the state understands what Mr. Copeland is talking about when he says when they shot at the car. The state has no intention of alluding that the they is Mr. Garlington and Mr. Stillwell trying to shoot at Mr. Copeland. And when I read this portion, I'm going to play for the court the entirety of that section, because I think in order to understand this section in context, you have to start at 438:14, because there's already evidence, or will be before this video is played, that there was a shooting on the highway in which Mr. Copeland was involved in. And the state in no way, shape, or form intends to infer that Mr. Demekion Garlington or Mr. Stillwell was trying to shoot at Mr. Copeland. That's not even something we thought of. So we'll play the whole section so you can hear it in context.
Fine. Can I get the page references?
Yes, Your Honor. We're going to start at, it's going to be roughly page 64. And I'm starting at 438:14, so it should be around line 2 on on page 64, line 2. And it will go through page 65, line 1.
All right, madam. All right, let me hear it, please.
In that fucking river with them, period. This is what is going on. These two people I be with, they're going to be Shannon and Lizzie. When I'm in with Shannon, me and Lizzie together all the time. That's exactly. This Shannon still on the Demekion Garland. Yeah. This me and him together all the time. Them only two I've been with. Since they shot they come, I've been in the house with my baby mama. If I ain't in the house, we don't got the ugly. And I don't call Queen. Queen don't can't pick that up, and we just rolled around here.
So we stopped it at 438:46. So in context, he's talking about the last time since they were shot at in the car. Well, before we played this interview, we would have played the January 28th interview where he's going to talk about the fact that they were shot at in the car in January 28th. And so when you read those two in conjunction with each other, I believe the jury will understand that he's saying since they got shot at the car, I've been in the house, given the full context. And again, the state will not infer that the they is Demikian, Mr. Garnis, and Mr. Stillwell shooting at Mr. Copeland.
Okay.
When I said the defense attorney's been spending a lot of time with this case, also the state has. I mean, they have a background understanding. Both sides have a background understanding that's through discovery that's deeper than what the jury has at this moment. And that this line adds nothing to the understanding of the case. But, you know, I just listened to it again. I was thinking maybe I missed something. He says there's no discussion of other people shooting at the car. They say, when's the last time you hung out with Shannon and Lil D? Not since they shot at the car. It sounds like my client shot at a car.
Well, it has to be taken in context because the jury's already heard about some purportedly shooting. Okay.
Yeah, but
I understand your concern under 403. I respectfully disagree at this point, but
okay.
Because I don't think it would confuse them. But anyways, anybody else wish to be heard on this issue? Mr. Weinstein? All right, Mr. Matthews, Ms. D. Williams, Mr. Harvey, Mr. Steele. Okay, all right. I'm going to admit it or allow it to be played over objection. I'll still give you a continuing objection, okay? All right. Let's turn to number 7. And number 7 is 60325 to 60605. And you...
By the way, it's page 155, line 1 through 156, line 2. 155, line 1 through 156, line 2.
You want to fight me?
Okay, Mr. Short. All right, let me frame the period. It's 60325 to 60605. It alleges Casey talking about Kel shooting and at some dice
At a gambling spot, which I believe under the state's theory is kind of one of the incidents that's the genesis of everything, of the disagreements between the groups. And my objection is that Kenneth Copeland is basically telling the police that Kel shot up the gambling spot, but even in his own statement, his identification of Kel, now let me be clear, he does say he was there, so it's not that he wasn't there, but from my understanding of his statement, he didn't know, no one knew who shot up the gambling spot, no one identified Kel, who's Kelvin Watts, at the time, but afterwards, apparently, according to Mr. Copeland, Kelvin Watts told his girlfriend or a girl that he knew at the time, whose name's Trivia, about what had happened and apparently made some confession, according to Mr. Copeland. And then Trivia tells Kenneth Copeland. So it's double hearsay. And certainly, even if Kelvin Watts to trivia would fall under a hearsay exception. Trivia to Kenneth Copeland would not fall under a hearsay exception. So it's hearsay, and he doesn't have a basis of knowledge, and we would object to its admission.
All right, State.
Your Honor, the information about the gambling spot has already come in based on the January 11th interview in which Kel discusses, if not January 11th, February 20th, but the two interviews that have already been played before the jury. Mr. Copeland has already said in both of those interviews that there was this incident at the gambling house in Lakewood, and that it was Kel who did it. And more importantly, when he met with Kel at the Cascade skating ring, maybe the next day after this gambling incident, that he talked to Kel about the shooting at the gambling house, and that it was during that meeting at the Cascade skating ring that Kel got on the phone with Mr. Williams, and Mr. Williams asked for Kel to pay for the window that was shot up at the gambling house. So one, the evidence is already before the jury about the gambling house. How we get to who told him is irrelevant, because it was the effect on the listener, meaning Mr. Copeland, that once he gathered this information, he's using this to try to squash the issues between Copeland and Kel. And so when he's relaying to Detective Gaither the beginning of the conflict between him and Copeland, he's just now reiterating how he got the information that Kel did it and what effect that had on the issues between the two of them. So who told Mr. Copeland that it was Kel is irrelevant to the sole fact that he thought it was Kel. That was kind of the beginning of their issues with each other. And as a result of knowing that it was Kel who did the shooting, Kel then in turn confronts Copeland Copeland in turn confronts Kel about this shooting. And during the course of his confrontation of Kel, also had a conversation between Kel and Mr. Williams about the shooting that occurred. So this portion as to how he found out it was Kel is not, while hearsay is really effect on the listener, but this is already information that's before the jury. But it's important, Your Honor, because let me say this, that defense counsel is arguing that Copeland consistently lies. What this shows is that Copeland's giving the same series of events to multiple different investigators at multiple different interviews. And so that shows that at least back in 2015, when he's recounting his history with him and Kel, he's telling different investigators these same series of events that occurred leading up to the murder of Donovan Thomas. But I'll play the section for you if you want to.
All right, sir. All right, yes, ma'am. Go ahead.
And I'm going to start at 6:03:22.
But that's what it was about. Then they got mad. The D got jumped in the club by NBC. They tell the D, we ain't got you because you be with them. They asked the D, why they ain't got you? I don't know why. It was no, but the whole time come back on Kevin because this is a gambling house. We go hang it and gamble. We go down and gamble. We come out the league. Kel in the bush. Kel Stewart, and they never mentioned the third person name. And Bush, they started showing them. They shot so many times. Yeah, I was glad they left. Huh? In Lakewood. They shot so many times. They shot down everybody's car. But they missed everybody. They graded one person across the back. But when police can't hear, left. Co-people left. But they don't care. But that's the same like NBC jumped on the D. So they did it and they seem like NBC did. But I pulled over and going home. I stayed out about 2 or 3 years. So I was telling them like, damn, bro, y'all nigga come on there, y'all trying to kill a nigga, what's up, bro? And they like, hell nah, bro, you tripping? Like, bro, we ain't see that y'all do with one of the NBC niggas. Like, bro, we ain't got no problem with that, bro. You didn't. Y'all trying to let TV with me, bro. I'm on the stage, I was like, nah, bro, y'all tripping, bro. In my palm, bro, nah. They keep trying to get in each other's face. But nah, and everything else, Big Boot came up there, and one of them on swarm. She grabbed the D out the stage, started jumping on the D. I ain't know it was a D, I'm thinking, they one of them jumping on them. So I walk out the club, see the D, him got the shine in his hand, and he blaming shit. Oh, what's wrong with you, bro? And he couldn't talk, he like, and I was seeing the hammer, but damn, they shot you too? So he went down there with him. He went to the hospital, so I had to tell him I'm with him. Then Pinky went down there with him. Goddamn, the next night we had gambling house. They ain't not putting no pictures, we in that gambling. They take pictures and shit. Then he came up and shot at it. We found out it was killed. He had got into a Gucci red. And she was talking to him. She came back and told her, like, man, it was killed and shot at y'all, making it like they did. Cause they shot at it and they went and shot at Monday spot. Monday we got into it with the MDC niggas. They bumped, boom. They had a fight started. They went shot at their house on Metro Pies. Shot house on Tuzlo. So that's.
And it ends at 6:06:07.
So to put a little context to what you just heard, this gambling spot was shot up, according to Mr. Copeland. It was assumed that it was people from a group called NBC, because according to Mr. Copeland, Mr. Kendrick had gotten into some sort of dispute with someone from NBC around that time, is what Mr. Copeland's saying. I don't know if that's true or not.
Mr. Kendrick, Mr. Garlington.
Mr. Kendrick. I think he says Monte. I'm assuming Mr. Kendrick. Might not, maybe someone else named Monte. And I don't know if any dispute occurred. But what he's saying is it was assumed it was NBC. And then through hearsay, it came out that it was Kel. Through hearsay, through trivia. And so our stance is that's hearsay. Effect on the listener is much narrower an exception to hearsay than the state's been putting forward in this case. Throughout this case, they've been relying on effect on the listener quite a bit. I don't believe that it's quite as easy to get around the hearsay rules under just saying effect on the listener. And his knowledge, he's giving a historical narrative of this event, and his knowledge of who committed the event or committed the act is based entirely on hearsay. So
what about the issue that we've heard testimony already about the gambling?
Then it's cumulative.
Then the shooting of the gambling house.
Well, if we've allowed that in the past, then that's on the defense counsel for not flagging that. But at this point, it's cumulative if it's come in already.
I believe it's already been testified to. In fact, I think Mr. Copeland earlier in his direct he's testified about that on the stand, about the shooting of the gambling house and this kind of historical perspective.
At this point, then it's cumulative, and if collectively we have missed it in the past, we're flagging it now.
Okay, all right. Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews? Ms. T. Williams? Mr. Harvey? Sir? Turn your mic on, sir, please.
I want to adopt what Mr. Shard said with regard to the effect on the listener. Effect on the listener is usually most often used as evidence of motive. It has not been used in that sense, and therefore it has been abused and continues to be abused as the basis for the admission of these clearly hearsay statements. So, for example, in Gates versus the state at 298 Georgia 324.
One more time, Gates.
Gates, 298 Georgia,
All right.
324.
Yes, sir.
There were text messages admitted that were sent to the defendant's girlfriend, not for their truth, but for the effect on the defendant in establishing motive for a murder. That's the usual basis upon which hearsay statements are admitted for the effect on the hearer. That is not the case here. This is not the defendant. It doesn't establish motive. So I would adopt and expand Mr. Sharp's reasoning.
All right, sir. Mr. Steele.
Nothing to add.
All right, sir.
nigga, I gotta live free in these streets. And I think what he knows, he gotta fuck up his But do you know why the biggest reason why they in this trial? You know, you might not just be putting it together, but you know, trust me, nigga, you know Fannie Willis is a DA.
Mm-hmm. Big nut.
Big nut, you know,
All right, folks, we're going to take a comfort break. Let's take 5 minutes. Come back. I'll make a ruling at that point in time on 7, okay?
And Your Honor, before the state did want to respond to what Mr. Harvey said, and so I didn't know if we could get an opportunity to do that prior to the court's ruling.
Okay. All right, recess.
May be admitted to show the effect on its hearer. See also Miller v. State 275 Georgia 32. For such a purpose, the statement would not be hearsay, as it was not offered for the truth of the matter asserted, but for the effect or lack thereof on the hearer. As such, Gates claims that this evidence was inadmissible because it was hearsay without merit. Here, again, Your Honor, learning about the fact that Kel shot at the gambling house, what Copeland took with that information is he confronted Kel about it. They had a discussion about not just the gambling house, but all their other issues that they had with each other. And then furthermore, during this interaction, which was, I believe, the next day after the gambling house or some time later, Mr. Williams then speaks to Kel about that shooting that happened at the gambling house, and specifically about paying for the window. So again, Your Honor, it's not about what, and I believe it's Gucci Red. I think Mr. Shar said that it was Trivia who said it, but I believe he said Gucci Red told us it was Kel. That information is what he used to confront Kel about about what happened at the gambling house. So that's what the state wanted to add.
What's your response to the defense's assertion as well as cumulative? Because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay. All right, councilors, I've had an opportunity to consider your arguments as well as take a look at Gates 298 Georgia at 324, as well as Garner versus the state at 342 Georgia Appeals 824. Both of them stand for the same proposition about effect on listeners. So I'm going to permit that to be the inquiry area of 60325 to 60. Hold on. Get back. Hold on. (60325) through 60605. All right. I'll give you a continuing objection, defense counsels, with respect to that. Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20. And I believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says he's concerned they would put the discovery on IGS or Instagram.
Yes.
Okay. Can you give me the page references, Mal?
Yes, Your Honor. So page 173, line 7 through page 174.
Okay. All right. Mr. Sharp.
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child. So we get into this, it's almost bolstering. It is bolstering, where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen. It has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals that are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals, and it's likely to confuse the issues. It's unfair prejudice towards our clients, where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403, 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/19/40.
You know my name? In that car, that's gonna put them there. Like you worried about the wrong thing. I'm worried about when you get locked up and you get a skirt, maybe to see how to circle each picture and put my name on them. You're gonna send it out to the screen and be like, I done told on him. And they're gonna put it out on Instagram, Twitter, and they're gonna tell everybody. And then guess what? They're gonna start like, damn, I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. You gonna do it, Woody, or you not?
And Your Honor, that's the conclusion at 6/19/44. And Miss, we started at 6/19/06. And Your Honor, may I respond?
Yes, ma'am. Okay. What's the state's response to Mr. Chardon, the defense attorney, saying that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland